resp.
My lady, I was taking you through the expert reports.
Yeah.
We'd seen that there was a clear statement in Professor Vicente's first report that what Unitel needed to do was make a claim within 6 months. That was then agreed by Professor Riviero, and it was only after that, and only after Unitel realised how problematic this would be for it, that Professor Vicente produced his second report. I took you through that. I've taken you through Professor Riviero's responsive report saying, well, if it's not going to be filing a claim, it has to be something procedurally equivalent, and she's set out what that would have to be. And in fact, we know as English lawyers that a joinder application is not procedurally equivalent to filing a claim. And so now we come on to Professor Vicente's attempted rebuttal. That's at tab 12, page 129 of the supplemental bundle.
Yeah.
And essentially what Professor Vicente tries to do in this report is he says that by requiring a joinder application to have certain consequences in order to be procedurally equivalent to filing a claim, Professor Riviero is assuming that filing a claim in Angola has those consequences. And in fact, he says it doesn't or may not. But the problem running throughout this report is that he imputes to Professor Riviero things that she doesn't actually say or assume. And so it's a total straw man argument. And I'll show you why. So if we start at page 134, and I'd invite the court to read this report in full in its own time, but in summary, at paragraphs 11 and 12, Professor Vicente says that Professor Riviero assumes that a claim filed in Angola has to be accepted. But in fact, it doesn't have to be accepted because it could be rejected altogether as inept, or the court has no jurisdiction, or it could be procedurally defective, and they would have to come back with another attempt. But so he says that Professor Riviero is wrong to say that to be procedurally equivalent to a claim in Angola, an application for joinder would have to be accepted. But Professor Riviero doesn't say that. She doesn't say that every claim in Angola has to be accepted. That would be a ridiculous proposition. Obviously, claims have to be adjudicated on their merits. Obviously, claims can be defective. Her point is simply that if you file a claim, you make a claim. Whereas if you file an application for permission to make a claim, you haven't filed a claim. And so to be procedurally equivalent, it would have to be that a permission application would necessarily result in a claim being made because the judge had to accept it and there was nothing further that needed to be done once it was accepted. But as we know, that isn't the case. And then there's a similar structured argument at paragraphs 13 and 14. So Professor Vicente says that Professor Riviero assumes that if you file a claim against a director, nothing more has to be done before there's a claim for damages against that director. And in fact, he says there is something that might have to be done. For example, you could bring a claim for certain relief, not including damages, and then apply to introduce a claim for damages later. So the reasoning goes, Professor Riviero is wrong to say that to be procedurally equivalent to a claim, an application for joinder has to result in a claim for damages being made without any further steps being required. But again, this just misrepresents what Professor Riviero is saying. Professor Riviero does not say that all claims against directors are necessarily claims for damages. Obviously, some claims against directors might be for something else. Obviously, you might have, in those circumstances, you might have to amend. Her point is simply that, again, if you file a claim for damages against a director, you've made a claim for damages against a director. Whereas if what you file is an application for permission to file a claim for damages against a director, in order for that to be equivalent to actually just going ahead and filing a claim, it would have to be the case that one leads inevitably to the other. And so therefore, again, you come back to the point of, well, the application would have to be obligatory to be accepted and no further steps would be required before that claim came into effect. And then finally, paragraphs 15 and 16, so we're now over the page in supplemental bundle on page 135. This time, Professor Vicente says that Professor Ribeiro assumes that if you file a claim, that automatically results in a director becoming a defendant to that claim. Whereas in fact, you can file a claim against one person, and then through something called provoked intervention, you can make that director a defendant to that claim later, whereas he or she wasn't previously. And so again, he says it's wrong for Professor Ribeiro to say that to be procedurally equivalent to a claim, a permission application has to automatically result in a director becoming a defendant. But again, Professor Ribeiro doesn't say that. She does not say that every claim filed in Angola will result in a specified director becoming a defendant to that claim. That's obviously not the case. It could be filed against somebody else. She's saying that if you file a claim against that director, then the director is a defendant to that claim. So to be procedurally equivalent to filing a claim against a director, an application for joinder would have to automatically result in them acquiring the status of a defendant in a claim, which it doesn't. So, my lords, my lady, I'm afraid this whole report is just one long confusion seeking to rebut arguments that were never actually made. And my learned friend asks in his skeleton argument, well, why didn't we file any evidence in response to this? Well, because we didn't need to. Anyone who reads Professor Ribeiro's second report and then reads Professor Vicente's third report will realise that this is just an attack on a straw man. So, if we bring all this together, my lords, my lady, the essence of it is this. Article 80 says that the thing that you have to do within 6 months is file a claim. The only way that filing an application for amendment and joinder, for permission to make a claim, the only way that that could possibly satisfy this requirement is if it was procedurally equivalent to filing a claim.
Well, this is filing an action.
Filing an action, filing a claim, yes.
Filing an action.
Yes, fine.
You gloss it by saying filing a claim because you want it to mean filing a substantive.
Well, it's filing an indemnity action,
yes.
The thing which is being filed, whatever you call it, or whatever we English speakers call it, it has to be a thing claiming damages from a director. You have to file an indemnity action claiming damages from the director. It can't just be anything. It has to be something asserting a claim for damages against the director. Has that addressed your point, my lord?
Well, it's addressed it. I'm not sure that it meets it in the way you're suggesting. But there we keep going.
Yes, so it would have to be procedurally equivalent to filing an action seeking damages against a director. But it isn't. Filing an application for permission to bring a claim is not the same thing as actually doing so. And Professor Vicente's attempts to suggest that it is, I'm afraid, just make him look like an advocate for his client. So, putting all this together, has Unitel discharged the burden of showing not just that it has an arguable case, but it has a good arguable case? We say no. No, it hasn't. If a good arguable case means, as we say, better of the argument, then we say that you can reliably conclude that we have the better of the argument. I mean, really, if the test is that, we say there's no contest. Clearly, Professor Ribeiro's analysis is more compelling than Professor Vicente's. So we do say on that basis that Unitel has no good arguable case. And my lord, to your point when you were addressing my learned friend, as I said at the outset, equally, even if it's a low merits threshold and then the merits come back in at the discretionary analysis, we would ask the court to take this into account when exercising any discretion that may arise at the conclusion of this hearing. So if we now just turn to look at how this was addressed by the judge.
Yeah.
It's core bundle tab 8, page 109. The context of this is the judge has just summarised the expert evidence. And then at paragraph 62, he says, if the need accession interpretation is correct, then he considers that the test is satisfied. Paragraph, and then paragraph 63, he says, if the test is the three-limb test from Brownlee, I must first try to decide who has the better of the argument, and he says he thinks that Unitel does. He agrees with Professor Vicente's view that the joinder application was equivalent to filing an action in Angola for the purposes of Article 80. And then he briefly explains his reasons why. In reaching this view, I note Professor Vicente's evidence that when an action is filed in Angola, the court does not have to accept it, and further acts may be required of the company. So essentially, the judge appears to have been persuaded by the first and second arguments in Vicente 3 that we've just looked at. But those arguments are, to say the least, not compelling on analysis. If you file an action, then you filed an action. If you file a claim, then you file the claim. The fact that that claim might then be rejected is irrelevant. You've done what Article 80 requires. If you file a joinder application, you haven't filed an action. So it can only be regarded as procedurally equivalent if it will inevitably result in the same legal effect. But as we know, it doesn't, because the joinder application can be refused or any permission given can not be acted on. Similarly, the fact that a person can file a claim against a director for something other than damages is neither here nor there. It's just another example of something like applying for joinder that doesn't involve the making of a claim for damages or bringing an action for damages against the director, which is what Article 80 requires on its terms. Now, my learned friend in his skeleton argument seeks to salvage this point by suggesting that if the claimant subsequently applies to amend to introduce a claim for damages via whatever procedural mechanism exists in Angola, that claim will relate back to the date of the original claim. But this is just speculation. Professor Vicente doesn't say that. This is just something that he has proposed might be the case. But he says, he tries to turn this around on us. He says, well, we should have put in evidence to say that this is not the case. But the burden of proof is not on us. The burden of showing that the claim has a good arguable, the claimant has a good arguable case is on the claimant. Why would we put in evidence rebutting an argument that hasn't been made?
But that's not the entirety of the basis of his, of what the judge has decided, is it? And what the judge, I mean, it seems to me the most important part of this is really what the judge says in paragraph 58 about Professor Vicente's evidence about the purpose of Article 81. And the judge comes back to what I think is probably the same point at paragraph 64.
Yes, well, let me address that.
He says that the joinder application precisely fulfills the purpose and therefore what is required under Article 80.
Yes, well, my lord, he's just wrong. I mean, as we saw when we were going through Professor Vicente's report, there was a passage where he said, and I can take you back to it if necessary, there was a passage where he said what's required is an expression of will. The judge appears to have fixated on that. And I'll look at paragraph 64 of his judgment in a second. But in fact, what Professor Vicente said was an expression of will within judicial proceedings and a procedural act. And he went on to explain what he meant by that as something which has the same consequence in terms of legal certainty and security as the filing of a claim. So if we, my lord, to your point, if we come on to paragraph 64 of the judgment, he says, it strikes me that in considering the questions of procedural equivalence, it's necessary to have in mind the purpose of Article 80, on the basis that Article 80 is concerned with the capacity of the company to act on the shareholders' resolution. Issuing and filing a joinder application seems to be precisely the sort of decisive step of this capacity that Article 80 requires. But Article 80 doesn't require a decisive step. It doesn't require a decisive exercise of the capacity conferred by Article 80. It requires the filing of an indemnity action against the director. The question is whether filing an application for permission to do so, for permission to bring a claim, is procedurally equivalent. And we see the same mistaken reasoning later down in the paragraph. He says, furthermore, because foreign companies effectively have to litigate in England via solicitors, don't, but he says that, who have to be instructed and go on the record and act for the company, issuing and filing the joinder application meant that Unitel solicitors Adelschul Goddard then had an actual or ostensible authority to conduct the litigation thereafter, even after the expiry of the 6-month period under Article 80, their appointment having been made before this. Looking at it in this way supports Professor Vicente's view. But I mean, this is wrong at a number of levels. One, I mean, it's just not right that foreign companies have to litigate, or indeed even in effect have to litigate in England via solicitors. Two, the issuing and filing of a joinder application doesn't necessarily mean that Adelschul Goddard had authority to conduct the litigation thereafter. They could have been instructed for a discrete task. But most fundamentally, the notion that merely instructing solicitors would be sufficient for the purposes of Article 80 is actually contrary to what Professor Vicente had said. And as I'll come back to the, it may be worth just turning this back up again, my lords, my ladies. Supplemental bundle, tab 10, page 111.
Well, that assumes that what he's saying there is that instructing solicitors is enough, which is in context. That's not the case.
Well, okay, this submission is directed on the assumption that that is what he's saying. That's how I'd read it, because in the context of him saying that what's required is a decisive exercise of the capacity conferred by the shareholders' resolution. But if we go back to what was actually said by Professor Vicente, paragraph 28, he had said, the question thus arises whether this requirement, the requirement for legal certainty and security, is satisfied not only by filing fresh proceedings, but rather by requesting the joinder of the director or former director at stage to pre-existing proceedings, so that the director becomes a respondent to proceedings will equally suffice. And then the reason he gives for why that's in the affirmative is not because there's a declaration of will or an expression of will, but because it serves the same purposes in terms of legal certainty and security and the other policy consideration that he'd identified. And he says in paragraph 30, in sum, what matters for the purposes of Article 80 is that the effect of the procedural act performed by the claimant be that of putting its director or former director in the position of respondent in judicial proceedings. Well, if what Mr. Justice Bright was saying was that instructing Adelschul Goddard and then coming on the record would be sufficient, I must say this is how I read his judgment, then that's just completely contrary to what Professor Vicente himself has said. And so we do say that the judge in this area was mistaken, clearly wrong.
Well, isn't your real difficulty what Professor Vicente says at paragraph 11 of his third report, which is picked up by the judge in his reference to the judge being able to reject a claim in Angola, when he talks about when faced with the initial application for a new claim, an Angolan judge is not obliged to accept it. So he's there treating the filing of an indemnity action as being, in substance, in Angola, an application for a new claim, which will only proceed if the judge accepts it. How is that functionally different from, in our jurisdiction, an application for permission to pursue the new claim by seeking leave to amend?
My lord, I don't believe that is what Professor Vicente is saying. He's not saying that you need to seek permission to make a claim. The thing which is
what he's saying is when you file an indemnity action, what you are doing is making an initial application for a new claim, which an Angolan judge is not obliged to accept. And whether that claim goes forward, therefore, will be a matter for the judge to decide.
My lord, that's not what Professor Vicente is saying.
What is he saying apparently?
He's saying an application for a new claim is the equivalent of what we would call a claim for. I mean, that is what he's saying is if you file a claim, that claim could be rejected on the basis that it's inept. Or
I agree with you. He is saying that that he is equiparating the filing of an indemnity action in Angola with an application for a new claim.
No, my lord, I don't believe
That's the expression he uses.
Yes, but my lord, I don't believe that that's what he.
And as a matter of sense, he explains why it's treated in that way, namely the judge doesn't have to accept it. And that seems to be the main point on which the judge focused, noting in particular that the judge doesn't have to accept a new claim.
Well, my lord, then the question becomes, well, what is the consequence of this in terms of legal certainty and security? If it's the case that it's sufficient for the purposes of Article 80 to file an application to bring a claim, then presumably the reason that it's sufficient is because once that's been done, if either it will then progress to a claim and there's legal certainty in terms of claims being asserted, or the application will be rejected, in which case there can be no claim, and in which case again there's certainty and security. The problem in this case is that if you file a joinder application and it's rejected, it doesn't in any way mean that you can't start new proceedings. You can, you just can't do so within the context of that claim. So from the perspective of the director, you're still left in a position of uncertainty.
So how does that differ from Angolan law?
Well,
You're saying
Angolan law,
you can't start a fresh claim in Angolan law.
No, exactly. You can't start. So either the claim has been rejected on the basis that it's inept, so presumably that's a merits defect. The court is manifestly incompetent, so a jurisdiction issue, or the claim is untimely, it's out of time. And the second alternative is to invite the claimant to complete it or correct it. But then importantly, the court then fixes a new time limit to submit a fresh application. So again, this will either inevitably result in a claim being made because they comply with that time limit and make another claim, or they won't, in which case, again, there's legal certainty because they haven't done, there's no claim.
So what he's there referring to as a fresh application is filing another indemnity action, is it?
Yes, you would have to, exactly.
So it's an application for what? Filing an indemnity action in that context is in his words, a fresh application for what?
It's essentially a fresh claim form, procedurally.
Well, it's a fresh application to be allowed to pursue the claim, isn't it? In the same way as an application to amend is in this country.
Fine, but my lord,
one must read it.
My lord, even if what you say is correct in terms of what Professor Vicente is trying to convey with the words initial application for a new claim, then the question becomes, as I say, what is the consequence if you file this and then you fail? The consequence is, it seems to me, is that if you file it and then the court rejects it because there's a problem with it, and then if the problem is substantive, then you're done, your claim is over. And if the problem is procedural, then you're given a time limit in which to fix it and come back. And if you fail to meet that time limit, then again, you're done and it's over. The problem, that's not the situation if you file an application for joinder and permission in this jurisdiction. You can file an application for joinder and it doesn't necessarily result in a claim being made or an action on this particular cause of action on this fact pattern being no longer available to you. I mean, this is precisely the point. If you take this step in Angola, then either the director knows that there is a claim being asserted against him, and he or she will have to meet that claim, or the claim is immediately dismissed, or they don't correct whatever procedural issues there are within the time set by the court. In which case, again, you've got legal certainty because you know that you're no longer going to have to face that claim because it's been dealt with. The same is not true of a joinder and permission application. If you're faced with a joinder and permission application, it could be rejected on its merits, but then a new claim be issued. So just because the joinder application has been rejected, it doesn't necessarily mean that you have legal certainty.
Yeah, I'm sorry, I just don't understand the distinction between that and the Angolan situation. We're not told you can't issue a fresh claim in Angola.
Well,
your premise seems to be that there's a complete cut-off, but we're not told that.
Well, you were told that there's a fixed time limit to submit a fresh application.
Well, that's it.
We're told you can do it in accordance with
yes.
a direction from the judge. We're not told whether you can do it irrespective of whether there's a new
I
time
mean,
limit imposed.
Obviously, the position in this jurisdiction is that subject to limitation period, you can have a go with a new claim if you've issued a defective claim which is struck down.
Well, only if you're within time.
Well, yes, but you're not prohibited from doing it.
But I mean, there would be no issue with. Okay, my lady, I see your point. Again, I think I can. Well, my lords, my lady, I think you're saying it's for us to have rebutted this, what I may say is quite an unclear point in respect of Vicente. I would contest that. The burden of proof is on the claimant to show that they have a good arguable case. If one looks at the policy considerations underpinning this area, legal certainty and security, it would be very
Now, this is
surprising.
never mind the burden of proof. I mean, the fact is that Professor Vicente, in a section of his first report from paragraph 26 through to 31, deals with all this in very clear and categorical terms, which the judge refers to, and makes it clear there that whether you do it by way of fresh proceedings or by an application of rejoinder, the effect is the same. The answer is in the affirmative. The purposes of Article 80 are satisfied. And that's the clearest possible evidence that the requirements of Article 80 would be satisfied by an application in Angola to join. And what happened here by way of an application to join your client to the existing proceedings was the procedural equivalent in England. Now, true it is your expert disagrees with all that, but it just seems to me impossible to say that that's not a good arguable case for the purposes of the exercise that we're engaged in.
Well, my lord,
What the result might be at the end of the day is neither here nor there.
no, my lord, I agree. Are you referring to the final passage in paragraph 16 of his, or which paragraph are you referring to?
I think it's the
Paragraphs
second
26 to 31 of his first report, page 111 to 112 of the supplementary one. He says it more than once. He says it about 3 times.
Yes, but my lord, if you recall, when I went through this is a proposition of English law.
No, it's not. You say it's a proposition of English law. What does it say it's a proposition of English law?
Well, he's making a statement about what the procedural and legal consequences are of an English joinder application.
Well, look at 24. In Angolan law, an action is deemed to be filed once the claimant's, not the noted claim, initial application was received at the court registry.
Yes.
He's treating an Angolan indemnity action as an application to pursue a claim, which he explains in his third report.
Pardon me, Lance. Yes. My lord, I think it's important to ask what is it that's being filed? In this case, it's an indemnity action that is being. Pardon me. If we go up to paragraph 23, the relevant procedural step is the filing of an indemnity action. And then in paragraph 24, in Angolan law, an action is deemed to have been filed once the claimant's initial application was received at the court registry. In English law, an action is not deemed to have been filed just because you've applied for joinder.
But we're not concerned. What we're concerned with is what's meant by the filing of the indemnity action as a matter of Angolan law.
Yes.
And whether the experts agree it is functionally equivalent to an application in this country for permission to amend, i.e. to seek permission to bring the claim. And if, as a matter of Angolan law, it's described here as an application, and as explained, it is in the third report, it's so described in Angolan law quite properly because it is no more than a provisional ability to pursue the claim which is subject to the permission of the judge to accept or reject it. Isn't that what he's saying?
Well, I mean, even if it is, I'm not sure it's sufficient for their purposes.
I mean, may be right, it may be wrong, but that's what he's saying. And it seems perfectly coherent.
Well, my lord, what they're saying is that if you file this an application to bring a claim in Angola, then you have brought a claim. So this is the crucial distinction between Angolan law and English law. If you file on Professor Vicente's evidence, if you file a permission application, you're treated as having brought an action, as having brought a claim. Now it may be, as I say, that permission is refused, but for the purposes of Article 80, you've satisfied the requirements. You're treated as having brought a claim. Whereas if you bring just a permission application in this jurisdiction, you're not treated as having brought a claim. You're just treated as having brought a permission application. And this is the crucial distinction.
Going back to the point you made a moment ago, Mr. Cooper, I mean, I read the whole of paragraphs, the whole of the section of his report headed 1, the relevant procedural step under Article 80 from paragraph 23 to 31, as describing what's required to be done as a matter of Angolan law. And he then goes on in the second, under heading 2, which you can pick up from paragraph 22, to deal with the specific question whether what was actually done in England was procedurally equivalent, complied with Article 80. But he's not in 23 to 31, he's not dealing with English law, he's dealing with the position in principle under Angolan laws, I read.
I'm afraid that may be true as a matter of general structure, but paragraph 29 is clearly a proposition of English law.
Well, it may be a proposition of English law as well.
But I mean, if it's a proposition of English law, then it's not a proposition that he's qualified to make.
Well, where does it say, where does it say anywhere in 23 to 31 that he is expressing views as to English law as opposed to...
Well, he can be expressing views as to English law without saying he's doing so. And he is. Okay. He's saying that, he's asked a rhetorical question. What step in England would have the same effect as filing an application for a claim in Angola? And he says that would a joinder application satisfy this requirement? And he goes on to say, yes, because the need for legal certainty and security, etc., is equally served, regardless of whether compensation is sought in proceedings brought independently or by an application for joinder of a director to which the director becomes a party. But he's suggesting that this is something which would be sufficient in England. He's making comments about what the legal consequences of filing a joinder application is in England. But, my Lord Justice Popplewell, to your point, it may well be, as I say, that in Angola, if you file an application for an action, you're treated as having filed an action. That's not the same in England. And so the two acts are not procedurally equivalent. And importantly, they're not procedurally equivalent in terms of legal certainty and security.
No, the question he's having to address is, what are the relevant features of the step you have to take in Angolan law in order to fulfil the requirement to stop time running under Article 80?
Yes.
And he's identifying the relevant feature as one which involves doing something, which is an application to pursue a claim, not the exercise of a right to pursue a claim.
My Lord, then the question becomes, well, what is the matter of Angolan law? Is the effect of making an application? And is it the same as the effect of making an application in England?
Yes,
and the answer is no.
Well, all he can tell us is what's the essential aspect of filing an indemnity action that's good enough for Article 80,
yes,
which he describes as being an application to be able to pursue the claim. Now then we ask ourselves, nothing to do with him, you say, because this is all English law, does making an application for permission to amend have those same functional features?
Yes, but my Lord, with respect, you seem to have answered that question in the affirmative just because the word application is used. But in Angola, it seems, making an application has a different legal effect to what making an application does in England. And so the two cannot be regarded as procedurally equivalent. The mere fact that you're making an application for permission...
We're not concerned with what the effect under English limitation law is of making an application for permission to amend. It's not subject to the respondent's notice points. That's not the issue that's here being addressed, is it?
No, my Lord, I agree with you. But as I say, the question is is if you do this step, which is required in Angola, which let's call it filing an application for permission to bring a claim, does that have the same legal consequences as if you file an application for permission to bring a claim in England?
Is it functionally and purposively equivalent?
Exactly. And the
Because
answer,
it's not happening in Angola, so it's happening under a different system, and the exercise that has to be undertaken is what's happening ex hypothesi not in Angola, something which fulfills the same purpose as that which in Angola would stop time running.
yes,
And therefore you look at the essential features from a purposive point of view of what does stop time running under Article 80, and you then examine whether the English procedure has the same purposive features.
well, my lord, I think we entirely agree on the analysis of
So far so good?
the question.
Yes.
Where I think we depart is that the Lordship seems to think that it's arguable that the consequence of taking this step in Angola is this functionally equivalent to taking this step in England. And I'm saying, my lord, based on the expert evidence that we have, that it's not.
Not functionally equivalent for the purposes of English Limitation Acts.
No, I'm
Not
not.
functionally equivalent for the purposes of Article 80. That's the
Yes,
question we're
indeed,
addressing.
exactly. So functionally equivalent for the purposes of Article 80. What is the purpose of Article 80? Is to make sure that there is legal certainty and security. What is going to bring about legal certainty and security is if a person knows that once this step has been taken, they are a defendant to an Angolan, they are a defendant to a claim for damages.
Well, I don't want to hold it down, but what Professor Vicente is saying is that they don't know that. The judge might reject it. They don't know that any more in Angola than the respondent to a permission application does in England. Isn't that the point he's making?
Well, my lord, if that is the point that it's making, it's in our respectful submission wrong, and it's not corroborated by Professor Ribeiro.
No, I entirely accept that. But that's not.
But I mean, my lord, just
beside the point.
if you ask yourself, what is the point of this provision? It's legal certainty and security. To the extent that Professor Vicente says that a step could be taken that doesn't result in legal certainty and security, then having just said that this is the whole point, that should cause this court to question whether what Professor Vicente says is right or indeed arguable.
Thank you.
Yes, my lord. I'm very conscious of time, and my learned friend will want to get on his feet. The last point remaining is the relation back arguments. Given the time, I think I'm going to have to rely quite heavily on my supplemental skeleton argument and take this relatively swiftly. So apologies. My learned friend has two fallback arguments. The first is that Article 80 is part of Angolan procedural law, and so doesn't apply here. In respect of that, can I just refer you to our supplemental skeleton argument, which identifies the relevant passages in the expert evidence, which makes clear that that is not right. His second argument is that if Article 80 is not a procedural rule, then it's a foreign limitation period, with the result that under Section 35 of the Limitation Act, the claim against Mr. Santos relates back to the date of issue of the claim against UIH, which is October 2020. My lord, I'm going to take this slightly out of order, because given the time. The essential answer to this is, even if relation back occurs, the consequences is that the claim is deemed issued before the shareholders' resolution authorising it was even passed. So this would be equally fatal to Unitel's claim. That's the easy answer. But in fact, this isn't a foreign limitation period. So I'm going to go on to make submissions which make good that proposition. My lords, in terms of the statutory, my lords, my lady, in terms of the statutory scheme, if we go to the authorities bundle, tab 46, page 1157.
Yeah.
This is the Foreign Limitation Periods Act, or the 1984 Act. Subsection 1 says that if an action is governed by foreign law, the law of that other country relating to limitation shall apply. Subsection 3 says that for the purpose of determining when proceedings have been commenced under English law, then Section 35, English law in Section 35 would apply. Section 35 being the section that causes relation back. If you go on to page 1159, that sets out the meaning of law relating to limitation. So much of the relevant law that a country, as in any matter, makes provision with respect to limitation periods, and limitation periods applicable to the bringing of proceedings in respect of the matter in the country in the courts of that country. And subsection 2 says that relevant law includes both procedural and substantive law. So essentially the question is Article 80 a limitation period? And there are two ways of looking at that question. The first is to ask, well, would an English lawyer, if this was imported into English law, would an English lawyer regard it as a limitation period? And an alternative way of looking at it is to say, if an Angolan lawyer was asked, is Article 80 a limitation period, how would they answer that question? We say that this is just a matter of construction as a statute as to what task it thinks, what task it is proposing should be undertaken. Our position is that the whole tenor of the 1984 Act is to defer to the applicable law on matters of limitation, and so that should include where the boundaries of the law of limitation lie. And so we say you should answer this question from the perspective of Angolan law. But it actually makes no difference on the facts of this case, as I'll come on to explain. In terms of Angolan law, I'll take you to Vicente 2, which is tab 10, page 107 in the supplemental bundle. We've looked at this before, so I'll take it relatively swiftly. Pardon me.
Tab 10.
Tab 10, page 107.
So which bundle are you in?
I'm in the supplemental bundle.
Yeah. Yeah.
Paragraph, we're in Vicente 2. Paragraph 9, referring to Article 80. Forfeiture period is distinct from a limitation period, such as that contained in Article 175. I'll take you to that in a second. And then paragraph 10, limitation periods differ from forfeiture periods in that they're, in various respects, they're usually longer. They're dictated by different policy considerations. Paragraph, over the page, we're now on paragraph 12. Accordingly, under Angolan law, forfeiture periods may be stipulated or amended contractually, may be waived, while limitation periods maybe not. Various further differences between forfeiture periods and limitation periods. And then he goes on to say that Article 80 is a forfeiture period. And in fact, there's another difference between forfeiture periods and limitation, or forfeiture and limitation, which is that limitation is purely about the expiry of time, whereas forfeiture can occur as a result of natural circumstances, such as death or, well, death is in fact the only example given. I'm not going to take you to the decision given time, but if I can give you the reference to that, it's back in the Portuguese Supreme Court judgment that we saw, tab 7, page 42, and actually the relevant passage is in page 50. But Angolan law does have limitation periods, and if you go to page 1169 in the authorities bundle, which is behind tab 48. So there's a chapter entitled Statute of Limitations. This is the limitation period applicable under Angolan law. So there's no question. If you would ask an Angolan lawyer, is Article 80 a limitation period, they would say no, it's a forfeiture period. So if instead you look at this from the perspective of English law, if this provision was imported into English law, would we regard it as a limitation period? There's no, or at least we haven't been able to find any authority which actually defines the word limitation period, but we do have a definition for statute of limitations. And that's in tab 1 of the authorities bundle. Page 4, the case of Gregory and Torquay Corporation. Essentially what happened in this case, it was a claim under the Fatal Accidents Act. There was an act called the Public Authorities Protection Act 1893, which provided that this kind of action had to be brought within 6 months. And the defendant put in a form saying just that the claim was barred by a statute of limitations. And the claimant took what was essentially a pleading point saying, well, the Public Authorities Protection Act is a statute of limitations. So the court had to consider what that phrase meant. And if you go to page 7, this is from Mr. Justice Pickford, is the highlighted passage. There's no definition of the expression of statute of limitations, but in my opinion it cannot be confined to statutes which by their title are so styled. I don't think it's right to hold that every statute which imposes a limitation upon a right of action is necessarily a statute of limitations. If a statute conferred a new right of action and also prescribed a time limit within which that right of action might be enforced, maybe that could not be properly called a statute of limitations. And then a little bit later he says, it seems to me that prima facie any statute which imposes a limitation of time upon an existing right of action is properly called a statute of limitations. And that case went up to the Court of Appeal, but there's no further analysis on this point. And so what we say is, in this case, we have a statute that confers a new right of action, the right to file an indemnity claim, and also prescribes a time limit within that right of action might be enforced, 6 months. So it falls outside of Mr. Justice Pickford's definition of a statute of limitations. So whether you look at it from an Angolan law perspective or an English law perspective, Article 80 is not a statute of limitations, and as a result, his whole argument on the basis of Section 35 doesn't get off the ground. My lords and my lady, I will say now, in our supplemental skeleton argument, we took a point on a case called Piarbi. We're not proposing to pursue that today. So after that, we go straight into the point which I alluded to at the start, that there are 2 requirements in this case. The first, or under Article 80, the first is to file a shareholders agreement, to file a shareholders resolution. My lords, may pardon me. There are 2 requirements. The first is the passage of a shareholders resolution, and the second is the filing of an indemnity action within 6 months from that resolution. If my learned friend is right, and relation back has occurred, this action was filed before the shareholders resolution was passed. And so that's equally fatal from the perspective of Article 80.
Mm-hmm. Right.
And my lords, just finally, and I'll take this very briefly, we say that if my learned friend is right on everything, I'm wrong on everything I've just said, my learned friend is entirely right, the relation back has occurred, and that's not fatal to him for the reason I've just described, then the consequence is this court had no power to grant joinder, because the effect has been that we've been deprived of what he says is a limitation defence. And just to make good that submission, if we go to the authorities bundle, tab 44, page 1154, this is section 35 of the Limitation Act, so the act that results in relation back. Subsection 1 says that where a new claim is made, B, in the case of any other new claim, it'll be deemed to be filed on or made on the same date as the original action. So that's what causes relation back. But then the key section is subsection 3. Except as provided by section 33 of this act or by rules of court, which is irrelevant because it's to do with personal injury and death claims, neither the High Court nor the County Court shall allow a new claim within subsection 1b, i.e. a claim to which relation back applies, other than a set-off or counterclaim, which this isn't, to be made in the course of any action after the expiry of any time limit under this Act, which would affect a new action to enforce that claim. So, and then it goes on to say that the court can make rules which provide for when a new claim may be brought in these circumstances, and those rules include subsection 5. In a case involving a new party, if the addition or substitution of a new party is necessary for the determination of an original action. And the long and short of it, my lords, my lady, in this case, is that it was not necessary for Mr. Santos to be added to the claim against UYH for that claim to be continued. So the High Court literally did not have the power to join her if what my learned friend said is right and relation back has occurred. And there is essentially two ways that the court could deal with that. Either it could remit this matter back to the court of first instance, or as we've submitted in our supplementary skeleton argument, it could set aside the jointer application, the jointer order itself, if it felt that, if it was persuaded by my learned friend's arguments. But I'm very conscious of time.
So we could set aside the jointer argument against which you've unsuccessfully sought to appeal.
Yes, my lord, yeah, yes.
How does that work procedurally?
My lord, I'm conscious of time. My lord, if you go to tab 45 in the authorities bundle, page 1156.
Yeah.
This is section 15 of the Senior Courts Act. This sets out your jurisdiction. Subsection 3, for all purposes of or incidental to, and we would rely on A, the hearing and determination of any appeal of the civil division of the Court of Appeal. The Court of Appeal shall have the authority and jurisdiction of the Court of Tribunal from which the appeal was brought. So the High Court has the authority to set aside an order, jointer order. Therefore, if such an order would be for a purpose of or incidental to the hearing or determination of any appeal, you can make the same order. If in the course of this appeal you conclude that, because of my learned friend's arguments, our limitation defence, if that's really what it is, has been defeated by joinder, in circumstances where that would not have been permitted, then you could, and we would say you should, exercise that power to set aside the jointer order. And then we've cited authority, which is there's authority in our supplementary skeleton argument which provides further analysis on this point, and I would refer you to that. But my lords, my lady, I'm conscious of time.
Right. Thank you.
I'm grateful.
Yes, Mr. Sinclair.
Yes, my lords, my lady. I'm going to endeavour to finish by 4:15 if I can.
We've got till 4:30.
Yes, I think I'm going to let my learned friend have
I see
a
what you
few
mean.
minutes
Yes,
to
okay.
reply.
Well, I think our current view, unless you go very fast, is that we're not going to finish this case today anyway. So I don't want you to feel under any pressure, because we've had quite a lot of fairly elaborate argument during the course of the day.
Right.
And no disrespect to Mr. Cooper, but he told us he'd been another half hour and he was in an hour. So.
Yes, my lord. Well, I'm in your lordship's hands in a way. I don't
just
want to rush.
Let's go. Let's get going and
Yes.
see how we go.
Okay, I'm very grateful. Thank you. So I'll take the issues in the order they were addressed to your lordship. So the first question is the meaning of good arguable case, which I will address in two parts. Firstly, as a matter of authority, whether the need accession test is the correct one, and secondly, as a matter of principle and policy. So dealing with the first of those, we would accept that in the freezing injunction's infancy, the court adopted a merits test which they gave the label good arguable case, because that was what the arguability test was called in the jurisdiction context. However, the court gave the merits test its own content in this context and the substance of the test in each context quickly diverged as the case law developed, as we will see. And as I will show, it's hardly surprising that the test should be different, as the jurisdiction and freezing order contexts are very different. And the role that good arguable case takes in those contexts is very different. And the differences have become even more distinct than they were originally. And one asks oneself, why should good arguable case mean the same in these two contexts? And there is no answer to that.
Other than it's the same words.
Yes, exactly. So it's a label. But
The label's the same, so you should decide that it means the same.
Yes.
Well, that's quite a conventional approach to
Well, it could be a starting point, but it doesn't follow logically. So, my lord, I think we can pick it up at the Pertamina case, which is in the authorities bundle behind tab 6, and Lord Denning. And obviously, as my learned friend pointed out, an important context to this decision was that at that time, the law at that time was that the court should not, in advance of judgment, allow a creditor to seize the goods of any defendant in the jurisdiction. We see that at page 60 of the bundle in Lord Denning's judgment at the top of page 659. So the law as it stood at that stage was that you couldn't seize the goods of someone within the jurisdiction. You had to get judgment and then do so.
That was Lister and Stubbs, wasn't it?
Yes.
Cited on page 659.
Correct, yes, my lord, thank you.
Perhaps
Yes.
more importantly, at this time, and arguably for the next 10 years or so, it was thought you couldn't get a Morava against an English resident defendant,
Yes.
irrespective of where the assets were.
I see. Yes.
So that at this stage, Morava injunctions were a creature which were only available against foreign defendants, I think I'm right in saying.
That's right. Yes, thank you, my lord.
At least
Yes.
thought to be so.
So it was thought to
So
be.
in most cases, you'd be seeking permission to serve out of the jurisdiction anyway,
That's
or leave to serve out of it.
Yes.
Then was.
so. Yes, exactly.
You
So
can see it was. You can see why. Perhaps it was thought the same
exactly.
test should apply.
I think so. So that would be our submission. These were both aspects of the court exercising an exorbitant jurisdiction over foreigners, which is obviously no longer the case, my lord. So, but Lord Denning analysed the test at page 62 in the passage my learned friend took you to, and just below E, he says he wouldn't limit the discretion to a summary judgment type test because of the risk of specious defences. And at G, he adopts the rubric good arguable case. And he says that's the test that applied for service on the defendant out of the jurisdiction, citing the Corner case, and says it's a good test in this procedure, which is appropriate when defendants are out of the jurisdiction. So that's where this content, one can see the analogy that Lord Denning had, that is no longer valid. And although Lord Denning doesn't really mention it, as your lordships are aware, the test of good arguable case in the Corner case is not a merit for the merits. It's not good arguable case on the merits. It's a good arguable case as to whether the case was a proper one to be heard in the courts. That's Lord Simon's at page 24 to 25 of this bundle. So, but I don't think Lord Denning spells that out here.
Does that explain the reference to American cyanamide? Namely, that in a case of the kind that's here being considered, if you were applying for an American cyanamide injunction, in that case too, you'd have to satisfy the test for service out because the context is a foreign defendant.
It may be.
Otherwise, it's rather difficult to reconcile the two.
It is difficult, my lord.
That might be why he said that. He's saying essentially, if we were to be being asked in the circumstances where a moraver is appropriate to grant a cyanamid injunction, we would still have to be satisfied that there was a good arguable case on the merits, brackets, because those circumstances are injunctions against foreign defendants.
Yes, my lord, your lordship could well be right on that. It's not clear what Lord Denning was getting out of the reference to American cyanamid. That may be the answer, but I can't think he was saying that. Well, as in he draws attention to the fact that under American cyanamid there's a requirement for just and convenient. It's also in conformity with the test as the granting of injunctions whenever it's just and convenient, as laid down in American cyanamid. But if that's the point he's making, it's not a particularly good one, in my submission, because obviously there's a requirement for it to be just and convenient in the freezing injunction context, as well as there being a merits test. So it's not...
It may be that my lord is right, that what he had in mind was a cyanamid injunction against a foreign defendant, where you'd have to satisfy the same tests under Order 11 as was. He says, whenever it is just and convenient, which suggests that that's an assumption. But it's very difficult to follow. It's not perhaps one of his finest judgments.
Yes, and therefore there's I think my learned friend draws from this case a suggestion that from its origin there was always a plan that the freezing injunction test would coincide with the jurisdiction test. But I think that's over-interpreting what Lord Denning was saying. I don't think that was in our submission anyway. That's not what Lord Denning was saying.
I mean, the argument was heard over the period, over 6 days, but I'm pretty certain from the top of page 653 of the report that when he delivered judgment on the turn, which he was very keen to do as much as possible.
Yes, my lord. And it's what's interesting, my lord, which goes to a point I think that cropped up a few times this morning, was at page 63, having set out the discussion of the test, when he goes to the application of the test, letter E, he considers first the question of whether it's just and convenient, and in considering that question, he looks at the strength of the parties' cases. And that's the point really. The merits test comes in at 2 stages as a threshold test, and then at the stage of assessing justice and convenience. And it's the threshold test that's the subject matter of this appeal. The threshold test is the good arguable case test. That is the only thing they're appealing. I know, I think particularly my old friend Mr. Olive Cooper was occasionally suggesting that he was challenging the merits insofar as it goes to the discretion assessment, but that is not the subject of this appeal. All your lordships are being asked to do is identify what's the merits test at the threshold stage.
But can I just ask for your help on how that works in practice?
Yeah.
I can see that you might, at the just and convenient stage, say, well, not only are the merits sufficient to meet the Niedersachsen threshold, but in this particular case, they are overwhelming. If I were asked to, I'd give summary judgment now, and that is therefore regarded as something which is of considerable weight in relation to the invasiveness of the relief. Essentially, you haven't yet got judgment, but you're bound to do so, say. I can see that the merits might apply in that way. What I have a little more difficulty with in my own mind at the moment is how they might be taken into account in the other direction. If you say, well, you have passed the threshold under the Niedersachsen test, but now when I come to the just and convenient element, the fact that they've only just passed that threshold means I should be less less willing to grant the freezing order?
Yes,
That-
that's so. I think
that's-
that's the idea, my lord, is that if you just squeeze over the through the threshold, and then the defendant presents very strong defences, for example, the court might say, well, given that you've got over the threshold, but you have a weak case, they seem to have some strong defences, then I'm and that does, and the case on dissipation was just good enough, but and there's other factors involved here, like the effect on third parties or something. Weighing all that in the balance, because this was a low merits case, I'm going to refuse the freezing order.
Have you come across an example of that in a reported case?
We certainly see that G emphasises that the merits are important at the discretion stage as well.
Right, and indeed, so did both Mr. Justice Mustill and Lord Justice Carr in Nidus Axon itself, but I'm not sure from my own experience I can remember it being argued even, and certainly I can't remember a case in which it's been said, well, you've only just met the merits threshold, and that's a factor which means I'm going to refuse you an injunction at stage 3.
That goes back to the point I was making this morning. I can certainly remember cases both as counsel and as a judge where you would refuse a moreover injunction on the basis you couldn't show the risk of or sufficient risk of dissipation. And I can't actually for the life of me remember one where it was refused on the basis that it was so close to the line on the merits of the case itself. Inappropriate to grant it.
No, my lord. I don't think any of the cases in the bundle are examples of that. I don't know that anyone has.
I read them all reasonably carefully.
Yes.
It doesn't mean that it's not the right approach. It's what's been said at Court of Appeal level, but
yes, I don't think anyone's looked for,
doesn't
for,
really
for
seem,
such
seem,
cases.
seem to be what happens in practice.
Your lordship may be right. I don't know that anyone's had a look for such cases, and maybe if one did, one could find some. But certainly the conventional view seems to be that, in principle, the merits can come in at the discretionary stage, and that makes sense in our submission, that one has a relatively a threshold that's not onerous, but then a discretion that can consider all sorts of issues. But
the early cases were ones, I mean, both Cara Georgius, which is arguably the first case, and Moreover itself were both cases involving claims of charter party hire, outstanding charter party hire, where the merits were pretty obvious, really.
yes.
I mean, there might have been defences to the claims, but in terms of was there a good arguable case that hire hadn't been paid pursuant to a charter party, it was pretty clear. So reading those, it doesn't seem to be any real analysis in any of the judgments,
No.
other than I think in one of them, which is Moreover itself, which I think was a withdrawal case, a repudiation case, where Lord Justice Ormwood, I notice, says, in my judgment, the Chancellors have a very strong case on the merits.
Yes.
And given his judgment, it's only 5 lines long, not much help to us, really.
Yes, my lord. I mean, the other point to make about the pertamina is that although Lord Denning identifies the rubric good arguable case, he doesn't actually analyse what its content is, other than to say it's less stringent than summary judgment. And so what we take from this case is that this is the case where good arguable case became the test. But in our submission, Lord Denning was not saying it necessarily had the same content as in the jurisdiction context. And what he certainly wasn't saying is that it would do so for all time and irrespective of how the changes happened in the jurisdiction context and the freezing order context as they have. So that was 1977.
And perhaps it's another indication of how this is at the very early stage in the development, that Mr. Justice Carr, as he then was in this case, thought essentially the merits test had to be Order 14, because it was such an extraordinary remedy as then perceived.
Yeah.
So these were very early days.
Yeah.
So, yes, I would agree with that, my lord.
You pick that up.
My lord, if we can then move on then to the need accession case, which is at tab 8.
Yeah.
And Mr. Justice Mustill, can we start at page 77, please? At the bottom of the page, just above the letter J, the judge was pointing out that applications of this nature can raise difficult problems, the more so as there's doubt as to the principles which should be applied. He says he'd had the benefit of very full argument on these principles, an argument much more extensive than is usually advanced on the hearing in the Raver proceedings. He thought it useful to adjourn the judgment into open court to point out some of the difficulties. And he expressed the view that it would be helpful for the appellate courts to provide some guidance. But the point I draw from that, my lord, is it does appear that Mr. Justice Mustill thought this was a judgment of some significance and general application, where he was trying to set out for the benefit of court users what he thought the test was for freezing injunctions. So it's not just a casual analysis by him. And then he goes on to analyse the principles, starting at the bottom of page 78. He refers to some of the older cases that we've talked about, and says that they're not easily reconciled, and then makes the point that we've been talking about, that to my mind they establish the strength of the plaintiff's case is relevant in two respects. Firstly, as to the threshold, and secondly, even where you've reached the threshold, the strength is to be weighed in the balance with other factors relevant to the exercise of the discretion. He then cites Lord Denning in the Pertimina, who had referred to Corner and American cyanamide. And then under the passage, he says this passage calls up two lines of authority. One relates to general principles governing the grant of interlocutory injunctions. It says, with great respect, he sees real difficulties there, and he identifies the differences that exist between interlocutory injunctions and freezing injunction, which is a point that we will come back to at some day when it comes to costs arguments. But they are different jurisdictions. And then he rejects the cyanamide good arguable case standard. And then he goes on to say F, the analogy with proceedings under Rule RSC Order 11 also seems rather distant. And he explains why there's a distinction between the Morava jurisdiction and the situation where one is in a jurisdiction dispute. And then he draws attention to the point that now Morava injunctions apply to people resident in the UK. So, my lord, what he's doing there in my submission, and rightly so, is drawing a distinction between the Morava situation and the jurisdiction situation, and rightly so. And indeed, he's also drawing a distinction between a freezing injunction and just the plain American cyanamide situation. He goes on to look at the Corner decision, nevertheless, and he looks at a decision of Lord Justice Carr, but then he sets out on page 80 at letter D what he considers to be the right test in the context of a freezing injunction. And so he was setting that definition within the context of the preceding cases. But on any fair reading of the judgment in our submission, he wasn't saying that the test needed to be the same in the freezing injunction context and the jurisdiction context. If anything, he was saying the opposite, because he was saying that the analogy between them was rather distant. And so that we submit is the orthodox test that was laid down 40 years ago. It was not purporting to be copying or consistent with the jurisdiction test, with the arguable case. And that is the test that has been applied ever since, and rightly so in our submission. And then if we go to what the Court of Appeal said about that.
Sorry, just before you leave
Yes.
that.
Yes.
What he says at 403D, distinguishing Moravas from other interlocutory injunctions, which are a reflection of a right giving rise to a cause of action. Again, very conventional then and for a long time while the Siskina held sway. But the juridical basis for freezing orders, Moravas, has now been explained by the Privy Council case, whose name I've forgotten. Thank you. As being equally principled. It's summarised, I think, in saying it's the vindication of a legal right to have the vindication of your legal rights protected, or not destroyed by the conduct of the defendant. And it may be that matters have moved on in terms of from where Mr. Justice Muster was in drawing a distinction between the nature of a freezing order and the nature of an American cyanamide injunction. They are different. One right is a substantive right to relief. The other is a right to have your substantive right to relief made effective. But they are both rights which the court is protecting by the grant of the injunction, and they both start from some element of merits which it's necessary to show in order to have the right protected.
Yes, but I think that the point that Mr. Justice Muster was making is that where one seeks an interlocutory injunction, you're vindicating the very right that you are then seeking to get relief from at the trial.
Yes.
And so you're getting early vindication of your supposed rights, which will then prove true or false.
That you get an in many cases, not all cases obviously, in many cases you get an interlocutory injunction, and you can then get a permanent injunction at trial.
Yes.
On the basis that is the relief you require in order to vindicate your legal
Yes.
rights, whereas a Morava, a freezing injunction, is protecting, as my lord says, it's protecting
Yes.
your interest in the legal right which you're in relation to which you're bringing the claim.
Yes.
But it doesn't lead to a permanent injunction.
Right. Yes.
Well,
Exactly.
say I suppose that it can be made
Well, it may
post judgment.
it may lead to a different sort of
post-judgment.
injunction, I suppose.
Yes,
a post-judgment injunction. But throughout, it's they're injunctions that are protecting your legal rights rather than directly reflecting your cause of action.
Yes. Exactly. So
I mean, I'm not suggesting that they are in any way identical,
No.
but it may be that the juridical basis for them is now regarded as not quite as distinct as it would have seemed to Mr. Justice Muster at the time when you couldn't
yes.
couldn't get a Morava without a substantive cause of action.
We're prefiguring the analysis on the cost situation, because we're in a where you get an interlocutory injunction, the starting point is the cost should be reserved because the right hasn't been decided for all time. Whereas we say in a freezing injunction case, it's different. And this debate will come up later. And indeed, we say when you look at convoy, as we will in that context, it maintains the distinction between the American cyanamide and freezing injunction.
But whilst I've blown you off course, can I ask you whether the test which is proposed in the Niedersachsen at
Yes.
404D is different in substance from the test of a serious issue to be tried as now understood as meaning more than arguable and carrying a degree of conviction?
I expect the difference is likely to be small in practice. But I don't think it's not our position they're the same. And I suppose there's a temptation for neatness in the law of saying that tests in different contexts could be the same. But I don't think that's necessarily right.
No, well, I understand that's what you say. It's just that if you're right in your argument, we have, as the judge observed, a rather unsatisfactory position.
Yeah.
The same label means two different things in two different contexts. And one might say, well, we better find another label
Yes.
in the present context. But if there is already a label which is adopted in what might be thought to be an analogous context of a cyanamide injunction, all the merits tests for jurisdiction, then if it really doesn't make much difference, that might be the label that we adopted. But you would think it means not quite the same. And it's no
I
part
don't.
of your
It's not necessarily the same. There's a whole body of jurisprudence on what it means in the American cyanamide case. And there's a body of jurisprudence on what it means in the freezing injunction case, good arguable case, and they're not exactly aligned. But in reality, I expect it's going to be rare that they would come to a different result.
Well, I think the serious issue to be tried, the jurisprudence is aligned, isn't it? Insofar as that is the test, A, for American cyanamide injunctions, B, for summary judgment, and C, I think, for applications to amend, which must meet that merits threshold. I think the jurisprudence has all been aligned in relation to those.
Well,
And the merits test on the jurisdiction.
And the merits test on jurisdiction, if I
Yeah,
can say
and the
that,
merits
yes,
test
yes.
for purposes of
Yes, well, my lord, I sympathise, and I agree with what Mr. Justice Bright said, that it doesn't make sense to have two tests with the same name which have a very different content, and that it would make sense to rename one, or if we're right, to rename one or other. I'm not sure we would go so far as to say that it's exactly aligned, but I think our position would be that they're effectively going to come up with the very similar results in almost every case. Don't know if that helps. So, my lord, if we can move on to the Court of Appeal, which starts at page 89. It's a judgment that was read out by Lord Justice Carr, but was the decision of the entire court. And he was considering he identified the two questions that the judge below had been considering at letter H. First, what's the probability of success at trial that you're required to demonstrate? And secondly, what's the prejudice in the shape of risk of dissipation that you're required to show? And so, as far as the first of those questions is, we say endorsed Mr. Justice Musthill. We can see that at page 90 at the bottom, right at the bottom of the page, and the highlighted passage is where it starts. Mentions the good arguable case test from the Pertamina. And they say just above B, we respectfully agree with it, but would add that this aspect of the evidence before the court should not be looked at in isolation when deciding whether or not to exercise discretion, which I draw from that, my lord, in our submission, that he's saying that the threshold is the good arguable case, and that then at the stage of discretion you can also look at the factual dispute again. And then, my lord, he drew attention to section 37 of the Supreme Court Act, which has the just and convenient test, At letter C, he referred to what were the new subsection 3, which dealt with the point about waivers against people domiciled in the jurisdiction. And then he had the passage which my learned friend I think showed you at page 415, letter D, where he says a good arguable case is no doubt the minimum which the plaintiff must show in order to cross the threshold, but at the end of the day the court must consider the evidence as a whole in deciding whether or not to exercise the statutory jurisdiction. So, my lord, we draw 2 points from this. First, this is a unanimous Court of Appeal, certainly endorsing Mr. Justice Mustill's judgment in the Nida session, where he had set out the test. There's scope for argument as to whether the Court of Appeal actually endorsed the specific wording that Mr. Justice Mustill had used. And different judges have come to a different view on that. The Court of Appeal Lord Justice Longmore in the Lacatania and Sue case thought that the Court of Appeal had endorsed Mr. Justice Mustill's test, although the Lord Justice Elias in the Kazakhstan case thought that they had not expressly approved it, but had not disagreed with it. Right. But our view is, I think, that Lord Justice Longmore's view is the better one, because if we turn to page 98 of the judgment at letter H, the Court of Appeal said that in the present case the judge correctly applied the 2 tests which failed to be considered on the facts. And the 2 tests being the test in respect of good arguable case and the test in respect of dissipation of assets. So we read this as not just them agreeing with the judgment of Mr. Justice Mustill, but agreeing with how he had applied the tests. And in other words, his identification of the Nida session test that's now referred to. Yeah. And secondly, my lord, the other point we take from this, the Court of Appeal, anyway, is the passage at page 91D, where they talk about the threshold and then considering the evidence as a whole, suggests or supports the view that the threshold test should not be too onerous, and that the analysis of the evidence as a whole, in other words, both sides' cases, comes in at the discretion stage. Then, my lord, if I can move on to Canada Trust, which I don't think I need to deal with very much, but that's at tab 12, where Lord Justice Waller explained the meaning of good arguable case in the jurisdiction context. Where he came up with a much better the argument test. Obviously, that was a jurisdiction case. There were 40 plus authorities referred to in the judgment, either in the judgment or in argument, as we see from page 150, and they were not freezing order cases. And as the court is aware, in the jurisdiction context, the good arguable case test is being applied not to the merits, but to the gateway question. And so undoubtedly is the case that the inquiry into jurisdictional gateway can sometimes be a wide-ranging one. But that will not always be the case, or even usually the case. Quite often it will be a very narrow question of where someone is domiciled, for example, or where a contract was entered into. And that sort of finely focused analysis is very different from the freewheeling question of the overall merits of the case, which raises issues as to causes of action, defences and foreign law and so on. Obviously there is a merits test in the jurisdictional context, but that's the very low one of serious issues to be tried. And there's nothing in the Canada Trust judgment or any of the further jurisdiction cases, which suggests that the court was saying this test should apply in a freezing order context as well.
Actually, interestingly, just picking up the point that my lord put to you a moment ago about to what extent can similarly good arguable case and serious issues be tried. If you look at what Lord Justice North said in his short judgment at page 572 between G and H, the authorities reviewed by Lord Justice Waller disclosed there may be at times been a measure of confusion between good arguable case and serious question to be tried or the like, perhaps because these expressions can mean different things at different minds. Summarize that there cannot be a serious question to be tried if the plaintiff does not have a good arguable case. So, I mean, he's making the point there that there may very well be some alignment between them, but the critical point, as he says, it's not a balance of probabilities test.
Yes, my lord. Then I think moving on, if we can, to tab 20.
Sorry to keep slowing you down, but
Yes, sorry.
we've skipped over Lewis and Freight Hire, which is at tab 11, which
Yes.
may be relatively limited value because it was an application for permission to appeal against a refusal to grant an order ex parte.
Yes.
But Lord Justice Millett says, 3/4 of the way down, don't believe there's any doubt about the law. The plaintiff who seeks Moravian must establish a sufficiently strong case to justify the relief, and a stronger case must be shown that will justify interlocutory relief of a less stringent kind. In one sense, the test is always the same. Must be satisfied the injunction sought is warranted by the circumstances of the case. At the least, the plaintiff will show there's a serious case to be tried, but a Moravian injunction is a more serious invasion of defendant's rights than other injunctions that seek to prevent a threatened wrongdoing. The context changes the standard of proof. So he did seem to think that something more than serious issue to be tried as a higher standard of proof was warranted because of the more stringent kind of relief.
Yes. Yes. As your lordship said, I don't know how much we can get out of this, given it was application for permission to appeal where one side was not represented, unreported, I think, as well. But yes, I mean, I wouldn't disagree with that. As in, I'm not trying to align the tests.
No.
But I don't know the extent to which the judge also had in mind. Obviously, there's the discretionary element on the freezing injunction. Once one's over the threshold, you're not there yet. You still have to satisfy the court that it's just and reasonable. Yes, my lord. So if we can move to tab 20, please, and the Lacatamia and Sue case. This was an appeal against freezing injunction that had been granted ex parte by Mr. Justice Blair and continued inter partes by Mr. Justice Beatson. And we see from paragraph 14 at page 328 that it was on the question of whether or not there was a good arguable case that permission to appeal had been sought. Lord Justice Tomlinson refused permission on the papers. Sir Mark Waller gave permission orally on the basis that the case against Mr. Sue was arguably too thin to justify the injunction, and it was not a matter of discretion. And counsel for Mr. Sue, who was Mr. Steinfeld, set out at paragraphs 15 onwards to a number of reasons why he was arguing that there was no good arguable case against Mr. Sue personally. He set out 4 or 5 reasons there. And at paragraph 19, the Lord Justice Longmore says that it's dangerous. It's inherently dangerous to get drawn into the detail of the argument, since one's tempted to express views on the very matter which is at issue in the case and will have to be determined at trial, that's not the proper function of interlocutory proceedings, and is indeed what the test of good arguable case laid down by authority is designed to avoid. And then he went on at paragraph 25 to endorse the test proposed by Mr. Justice Mustill in the Need Accession case as approved by Lord Justice Carr, which was the point I made before, that he seemed to think the Court of Appeal had approved Mr. Justice Mustill's decision. So that is clear authority, we would say, at Court of Appeal level, that the Mustill formulation of good arguable case is the right test, even after the Canada Trust decision. And it's a unanimous decision of the Court of Appeal. And then we move on, my lords, to the Kazakhstan case, which is at tab 22. And we can see what Lord Justice Longmore said there in paragraph 25.
Sorry, tab.
I'm sorry.
Sorry, it's my.
It's tempted. I have double-sided pages, so I'm in the same file, so I'm ahead of your lordship, I'm afraid.
Yeah, it's just got the wrong file. So,
So it's tab 22.
Yeah.
At page 429 is part of Lord Justice Longmore's judgment in the Kazakhstan case. And paragraph 25, he said that the test of much better the argument is setting the hurdle a little too high. He refers to the pertamina, and he observed that there was no reason why the test in the jurisdiction context should apply to freezing injunction context. And we would agree with that proposition. There's more analysis. Obviously, he was the judge in the Lakitamia Nobusu case as well that we were just looking at, so he's very familiar with the
So it's the same point in Lord Justice Elias's judgment, isn't it? 66.
Yes. Exactly, my lord. And indeed, just before we get to Lord Justice Elias, if we look at Lord Justice Jackson, which is at 437, he said that paragraph 52, the appeal should be dismissed. Paragraph 53, he says, having said that, I regard the arguments raised by Mr. Howard as formidable. There's a very real possibility the defendant's limitation defence will prevail at trial on the basis of Kazakh law, the effect of which is agreed between the parties. It's only by a narrow margin that the claimant's case is strong enough to support their entitlement to a freezing injunction, which is, and that finding is very far from the sort of saying that the claimant had a better case or a much better case, whatever. He's saying on the contrary. And indeed, it's a fortiori to our case, by the way, where we also have a let's say limitation forfeiture type case where the law is very much not agreed. And then, as your lordship says, Lord Justice Elias has quite detailed analysis in our submission, where he goes through paragraph 63 to 68 the various relevant authorities in this area. He refers paragraph 66 to the Need Accession test as being the traditional test. At paragraph 67, he explains why the bifurcation of the tests between the jurisdiction context and the freezing order context is appropriate, given developments in the law on jurisdiction. Although it's fair to accept that the point he makes at paragraph 68, that they didn't have argument on this point. And he was not expressing a concluded view.
He, it is in that last bit of 67, who comes pretty close to equating the good arguable case test in the freezing injunction case, the threshold test, with the test, the merits test under
Yes.
jurisdiction applications for permission to serve out.
Yes.
Serious issue to be tried.
Which is if one did want to draw an analogy with the jurisdiction context, obviously it should be with the merits test. That's right.
Yeah.
Because we're
Well,
looking
that's
at two
the
different
point he's
merits tests.
making.
Yes, exactly. So
In both instances, you're looking at the merits,
yes.
whereas the jurisdiction good arguable case at this stage of, I think, much the better of the argument is looking at whether you could get yourself through one of the gateways.
Yes. And one can see why that should have a higher test, because
It's the foundation of the
it's-
jurisdiction.
It's foundations of jurisdiction, exactly. And it's a question that may never arise again.
Well, it usually doesn't,
Usually doesn't.
when you come back from the Supreme Court.
Yes, and it's a once and done. Once you've established jurisdiction over someone, they're now stuck
Yeah.
in England. Whereas if you get a freezing injunction against someone, and it turns out that you forged some documents or something, it can be set aside later. You
Yeah.
can't. Once you're in the jurisdiction, you're in. And then, my lord, so then we have the judgment at tab 23, which is another Lacatamia case, and where Lord Justice Tomlinson approved the passage from my lord's judgment in the Maximov case, which is at page 456. About the Chabra jurisdiction, but it appears to set out clearly a view of of my lord in Maximov as to the meaning of good arguable case, and is cited with apparent approval by Lord Justice Tomlinson, with whom Sir Bernard Ricks agreed. So, my lord, we say this is 3 cases at Court of Appeal level endorsing the need accession test after Canada Trust and reflecting the divergence of the test for a good arguable case between freezing order and jurisdiction contexts. And then, my lord, the next authority in the sequence is the Hollyoak and Candy at tab 26 of the bundle. Judgment of Mr. Justice Nugie. And if we pick it up, please, at paragraph 9, which is at page 503, the judge set out there the 2 questions that he was considering. One was whether you have to show a serious issue to be tried or something else, or good arguable case, because this wasn't a freezing injunction, it was a notification injunction. And secondly, if it is good arguable case, what does that mean? And he answered the first question at paragraph 10 by saying you have to show a good arguable case. And then he answered the second question at paragraph 11 onwards. And so he began by looking at the historical cases that we've looked at, Pertamina and Corner and so on. And then he cites Mr. Justice Mustill's test in the need accession. He then refers to Lord Justice Waller in Canada Trust at paragraph 12. And then at paragraph 13, he considers the argument by counsel that this development in Canada Trust should be applied in the freezing injunction context. And he relied on the 3 cases my learned friend relied on to support that proposition. The judge was then had some sympathy with what Mr. Justice Toulson had said in Petroleum Investments.
But he makes the point, doesn't he, which struck me when we were shown paragraph 38. Mr. Justice Nugee makes the point that Mr. Justice Toulson's judgment at 38 is more nuanced
Yes.
than Mr. McQuater was prepared to accept,
Exactly.
which I think must be right when you read it.
Yes, it's
I don't
not.
think it is necessarily, I mean, true it is that both Mr. Sutcliffe's case and Mr. Justice Ross' case are on, as it were, on the other side of the fence.
Yes,
But I don't think the Toulson case really is. I think it's very much.
I'd agree with that. Yes, so it's not a read across of the test
No.
from one context to the other. No, that's right, my lord. And then he considered the Kazakhstan case, in paragraph 14, that we have looked at, and he says that the Court of Appeal, or the two judges there, expressed significant reservations about applying in the context of freezing injunction the test and much the better of the argument. He wasn't limiting that to a situation where there's a dispute on the facts. I think what my learned friend wants to draw from this case is that Mr. Justice Nugee was saying, well, there's a special rule where it's a factual dispute. But that's not what he says in paragraph 14. And then he goes on to then he refers to the Lactamia case.
He makes a point that, which is at 15, doesn't he? That perhaps you haven't got there yet, but I just think he makes the point at 15, which is really the same point as Mr. Justice Butcher makes, and I think the judge in the present case made. But the invidiousness of having to make having said, well, you got the better of the argument.
Yes.
When you've got hotly contested cases, which at the least at the freezing injunction stage will quite often only be one side's pleading and possibly a witness statement, and then on the other side, not even necessarily a defence, but a witness statement saying, well, this is all, the claimant's case is all complete rubbish for the following reasons.
Yes. Yes. Right. Yes, and I'll come back to that. I think when I address the policy side of this, why it's a sensible case. But just that's right. But just above 15, though, can I just draw your lordship's attention to they cite at letter E what Lord Justice Longmore said in Lactamia, that there was that it was far from obvious that the test should have the same meaning in each context. So so Mr. Justice Nugee seems to be endorsing what Lord Justice Longmore said, that there should be a divergence between the two contexts. And having set out all that, so at paragraph 15, he says, in these circumstances, I'm free to follow Mr. Justice Toulson in Petroleum and the Court of Appeal in the Kazakhstan Ghazi case. He's not obliged to follow the much the better of the argument test. And then he says, in the case of purely factual questions, I consider it sufficient for the claimant to meet the traditional test laid down by Mr. Justice Mustill in the Niedersachsen case. So, my lord, there's no reasonable interpretation in our submission of Mr. Justice Nugee, other than that he is recognising and agreeing with the analysis in the Court of Appeal cases of Lactamia and Kazakhstan. And although he says, he uses the words, in the case of purely factual questions, he considers the traditional test, that's only in our submission because the case before him was a purely factual one. It was, as indeed is ours. It's a question of foreign law, which is a question of fact. So but in our submission, he was not purporting to restrict Mr. Justice Mustill's test to factual cases only, and nor indeed could he have done so, since the Court of Appeal has apparently expressed the test generally. So we don't accept, I'm sorry.
There may be a distinction, again, which is also reflected in the summary judgment context, between factual disputes and a point of law in which the court is in the same position as it will be at trial, one hypothesises, and therefore the court will grapple with the point of law. It won't just say it's arguable. And that may be so if it's a question of construction, which is not going to be affected by any factual matrix evidence. So it may be that there is a basis for a distinction, and that this is what Mr. Justice Toulson had in mind in Cantupan, between cases in which the court is in as good a position as it's ever going to be to reach a conclusion on the issue.
Yes.
And those where it's evidence dependent.
Well, I see that, my lord. I wonder whether one looks at it as though as the court saying, well, I'll decide this point now, and having decided it, your case isn't arguable, it's wrong. I don't know whether that's another way to look at it, fitting it within the same framework. But your lordship may be right, that where it's a pure legal question, that all the material's there, then the court should grasp the horns and resolve it. But
perhaps subject to all the reservations one gets in strikeout cases about not doing it on facts that haven't yet been found.
yes. Yes, it would have to be a purely legal case that's irrespective of the facts. It's going to be a very rare situation, I think, where that can be done safely. Yes, I hear what your lordship says. It's not our case, so it doesn't matter too much to me.
How one tries to reconcile the various
Yes.
strands.
Yes, I see that. But what I don't take from Mr. Justice Nugee is he's saying that only where it's a purely factual case does Mr. Justice Mustill's test apply, and that where, for example, they're legal and factual questions, or in the general run of a case, is the needs accession test should not apply. So, my lord, we would submit that Mr. Justice Nugee is a case in our favour rather than against. But and then we come, my lord, to the key case from my learned friends, which is.
Do we get anything from the Court of Appeal in
Not
Camden?
not really, my lord.
I mean, I think
because,
I wondered about that. I mean, then Lady Justice Gloucester does set out. I mean, interestingly, she says that paragraph 18, subparagraph 2, page 530 of the Bible. In order for the claimant to obtain a notification injunction, the claimant has to show a good arguable case on the underlying merits. That was to say, a notification was subject to the more stringent merits test to be applied in respect of conventional freezing orders, rather than the lesser test of there being a serious issue to be tried, applicable to other interim injunctions. So she seems to have thought that there wasn't necessarily an equivalence.
Yes, I think it's fair to say the general tenor of the authorities seems to assume that serious issue to be tried is slightly less onerous than good arguable case, but where the difference is going to be marginal, I suppose.
Yeah, quite. Okay, right. Sorry, you.
I was going to move on, if I may, to the Morimoto case, which is behind tab 30.
Right.
And this case is really the linchpin of the claimant's case. Sorry, the appellant's case.
Yeah.
Their case is that this judgment rewrote the established jurisprudence as to the test for good arguable case in freezing injunctions. So we can pick it up at paragraph 33 of Lord Justice Haddon Cave's judgment at page 650, where he begins paragraph 33 by saying that the basic legal principles are well known and uncontroversial and hardly need restating.
Which we start for rewriting the law. Really.
Yes, exactly. And indeed, we would say that it's impossible to reconcile that statement with the suggestion that he was about to go on to change the well-established orthodox need accession test. And lordships need to bear in mind that even the appellants appear to accept, even on their own case, that Morimoto was changing the law and reunifying the previous bifurcation of the law between jurisdiction, freezing, injunction context. And we see that from their skeleton at paragraph 39, where they refer to this case as having reunified the tests. In other words, yes, they say because the reunification of the test was done without much attention being drawn to it, everyone missed it. So it's their case. The use of the word reunification shows what their case is. It started with Lord Denning, where the tests were together. They then split, as we've seen from the various Court of Appeal authorities saying that why should the tests be the same? And their case is that this case reunified them. And yet, which would be a dramatic occurrence, and yet it's something that Lord Justice Hatton Cave starts by saying that the test is well known and uncontroversial. That, in our submission, cannot be reconciled. Anyway, so he begins by saying that the test is not particularly onerous then, at paragraph 35. Again, that, in our submission, is inconsistent with the suggestion that he's about to apply a much more onerous requirement, which has been developed in the jurisdiction context. He would not say that, if that's what he meant. He refers to G in the 6th edition at passage 12026. I don't know if it would, your lordships would be interested to see what G says there. It's in the supplementary authorities bundle. It hadn't made it in the original authorities bundle, but it's made it into the supplementary one. Behind tab 2. So
It's the same.
yes, it's the same, and I think the not particularly onerous is the sentence which is attached to footnote 113. The test is not a particularly onerous one, and that is then footnoted to the Kazakhstan case as well as another case. But if your lordships read what G says in those few paragraphs in that edition, they set out the standard need accession test and approach as being the correct one. And indeed, at the top of page 399, the authors of G say the test is not whether the applicant has much the better of the argument, which is a test used for permission-served proceedings out of the jurisdiction. So the authors were drawing that distinction in a passage that the judge, Lord Justice Hatton Cave, seems to have read and approved. So then going back to Morimoto, he then refers to, in paragraph 37, Mr. Justice Mustill's well-known observation in the need accession, which he sets out in terms, and then goes on to observe that there had been case law in jurisdiction cases, which he identifies there, and then says that the central concept at the heart of the test was a plausible evidential basis. In our submission, the judge was not importing the whole jurisprudence on good arguable case in the jurisdiction context into the freezing injunction context. He didn't set out the jurisprudence on the Brownlee test and the Goldman Sachs analysis in his judgment. If he was purporting to introduce these into the freezing order context, he would have set out the 3 stages and so on, and said this is the test that now applies. He doesn't do that. He takes a piece of the analysis out, which is the plausible evidential basis. But that is not the full story at all. And so on any fair reading, Morimoto did not change the law on the meaning of good arguable case. And there are numerous, it's common ground between the parties that since Morimoto, there have been numerous first instance decisions that continue to apply need accession after Morimoto. We found at least 10, and we cited a few in our footnotes, one in our skeleton. It's common ground, so we haven't included them in the bundle. So, but most, or many judges continue to apply need accession, notwithstanding Morimoto. A few of them, even where they've cited Morimoto, still continue to apply need accession in the usual way. The textbook writers continue to endorse need accession, notwithstanding Morimoto. And your lordship saw that
I think Mr. G's, I think the equivalent paragraph from the 7th edition
yes,
of G is in the authority's
it
bundle.
is, yes, and indeed the white book, time may not permit, but the white book, the reference is page 1201 of the authority's bundle. G in the 7th edition, the reference is 1192 of the bundle. O'Hare in the 20th edition, that's at 1181 of the bundle. But against that, my learned friends have found 3 decisions only which have analysed Morimoto as if it did reunify the test for good arguable case. Those are Zhivago, which is Lord's case at tab 35.
Well, hang on a moment. Wait.
Which is primarily a judgment on jurisdiction issues. As far as
The difficulty is, and I looked at this again and tried to remember what it was that I had indicated during the course of argument. But in other cases, I don't think, I can't remember to be, if I'm actually honest, but I don't think as a Court of Appeal judge, I had looked at the Niedersachsen on an appeal other than in this case. Well, this was at first instance anyway, but certainly when I was in the commercial court, I applied the Niedersachsen time and again. There was a case, I can't remember the name of the case, which I think you were in as well, pyramid
is it Raven? my lord?
case. Sorry?
Raven?
Yes, well remembered, yes. Madoff and Raven, because I think it was both in that. I'm, from recollection, applied the Niedersachsen in that case.
Yes.
So,
Yes, I think my learned junior has did his research knowing the panel, and says that I think you observed in that case that there was probably a limited difference between the serious issue to be tried and good arguable case test.
Then I dismiss the claimant from.
But as far as the Zhivago goes, my lord, you address this at paragraph 167 onwards, at page 749, where you expressly state that it is obiter, because you'd already decided the point on jurisdiction basis. Then you identify the 3 issues on freezing injunction, and then at paragraph 170 you say the test of good arguable cases was recently confirmed by the Court of Appeal in L'Aquitania Morimoto, which you set out there, and then you say during the course of argument you indicated you were satisfied with that and take a realistic approach. Counsel didn't persuade you to the contrary. So it looks as if this wasn't the subject of any discussion, really.
No.
And at paragraph 172, you say that the issue that was particularly in dispute was the one on risk of dissipation, where you set out in depth the law. So in our submission, this is a good judgment in jurisdiction circles. It's frequently analysed on that basis, but it doesn't really move the analysis forward, we would say, on this particular question, respectfully.
Yeah.
My Lord and Lady, the next judgment that my learned friends have found that deals with this is Harrington, which is at tab 39, where the court, the analysis starts at page 960, and the court sets out quite assiduously the relevant case law in this area over a number of paragraphs, where that is largely a cut and paste of the key passages from the texts. And then the judge gets at page 965 to the Morimoto case, where he cites Lord Justice Haddon Cave, refers in paragraph 253 to Zhivago, and then he notes that the claimants had contended it was wrong to conflate the test in the two contexts, but the judge seemed to interpret Lord Justice Haddon Cave as not having drawn that distinction. But there's no real analysis by him in our submission, and as I hope I've shown your lordships and your ladyship, that is not our interpretation of Lord Justice Haddon Cave.
No.
And then the final authority my learned friends have been able to find is Chowgul, which is at tab 41, and paragraphs 43 onwards of Mrs. Justice Dias's judgment, which is at page 1045. She considers the authorities on good arguable case, where she refers to Kiefer, Brownlee, Goldman Sachs, and then says at 46 that she approaches the present application on that basis. So she's not, doesn't consider Morimoto on this point at all, but simply seems to assume that the test in the jurisdiction context on the meaning of good arguable cases this should be the same. And Mr. Salzedo of counsel at paragraph 48 drew attention to what G on commercial injunctions had said, that there should be a different test, but she rejected that. But the only basis for that is at paragraph 49, where she says that given the serious consequences of a freezing order, she has doubts as to whether it would ever be appropriate to grant a freezing order unless the court was satisfied the claimant did have the better of the argument. But that has never been the law in our submission, that the seriousness of the consequences means that justifies that requirement for the test. The seriousness of the freezing orders has always been the case, even when the need accession test was laid down and followed repeatedly. So with respect, we do not accept the analysis of the judge in that case. So those are the only three cases that they have found as against, to be weighed in the balance, against the numerous Court of Appeal cases that pre-Morimoto and the numerous first instance decisions post-Morimoto, all the textbook writers, Mr. Justice Butcher, and Mr. Justice Bright, indeed. And we are not going to take your lordships through it, but the analysis of Mr. Justice Butcher, sorry, my ladyship, the analysis of Mr. Justice Butcher in Medov at tab 42 is very persuasive in our submission, is correct.
Yeah.
So
But he really addresses all the issues that we're considering.
It does. So we say, as a matter of authority, the need accession test remains the relevant test, and Morimoto has not changed that. Can I address then the second question I was going to...
Just before you do so, can
Yes.
I make a couple of quick request.
Yes,
Could we be provided with my Lord's judgment in Madoff and Raven
yes.
to see what he said about the tests being different or similar? And secondly, I noticed that in the 6th edition of G, maybe in the 7th as well, there's a footnote referring to what Lord Justice Millett had said, but suggesting that that wasn't the view that was taken in other Commonwealth authorities. I think there's a reference to an Australian case and to a British Columbia case. I don't know whether more generally there's anything in Commonwealth authorities that might help us on this, both on the general point as to what the merits test should be, and on whether there's any difference between the Anglo-Saxon's tests and serious issue to be tried.
Yeah.
And we promise not to do to you what Mr. Justice Brandon once did to Mr. Tomlinson, which was and I think it was Bruce Reynolds in a case called the Burney, where he said to counsel on about day 5, has anybody bothered to look at the Commonwealth authorities? So they all scurried off, looked at the Commonwealth authorities, and then cited them to him for about a day and a half. And in his judgment, he said, counsel saw fit to cite a number of Commonwealth authorities. I cannot understand why they did so.
Yes. Yeah, we can certainly provide Madoff and Raven. As far as the Commonwealth authorities, I'm not sure that either team has looked into that. How I anticipate we're not going to finish today.
Well, that's why I made the...
Yes. So is the idea that I would address you orally on those next time, and then my learned friend can reply?
Well, if you identify something that might be of use.
Yes.
Yes. I think
having it in advance with some brief, a page or two of why you say it's
if there's anything
would be helpful rather than having it cold.
Yeah, if there's anything of
first
any
time.
relevance, then it would be helpful.
Yes. Can I suggest a page limit, a small page limit, because otherwise we will get reams, or we may get reams from
I'm perfectly happy.
2 pages.
10 pages?
Between
I'm master of the roll now. 10-page limit, please.
Yes, my lord, we will do that. As far as the question of principle is concerned, the first point is why beyond having the same name, why should they have the same content, and given the complete difference between the context in which they're applied. My lords, my lady, picking up a point that was made to me, is, as a matter of principle, is what Mr. Justice Nugee said in Holyoke and Candy, which is at tab 26. At paragraph 15, we would respectfully endorse what the judge said there. I'm sorry, it's paragraph 15, my lady, on page 506, and I think it was the point that my lord Chancellor made to me. In paragraph 15, the judge said it was the invidiousness of trying to decide which party had the better of the arguments. It's wholly invidious in a case which turns largely on the credibility of the principals and their oral conversations in that case. Nothing other than pleaded cases, assertions, to form a view as to where the better of the argument lies. And in my submission, that would apply generally to any situation where your lordship and your ladyship are trying to determine questions but on paper. For example, my learned friend, Mr. Oliver Cooper, made a series of assertions that our expert was in some way an advocate for us, and various quite serious allegations, I would say, about his partiality.
None of which has been tested by cross-examination.
No, exactly. That sort of allegation is one that must be tested by cross-examination. My lord, then we would, as a matter of principle, we would also endorse what G say, citing Derby and Weldon. It's in the bundle behind tab 52. It's page 435 of G. And it's about 7 lines up from the bottom of the text, above the footnotes, where he says a requirement that the court must form the provisional view that the claimant will probably succeed at trial would be inconsistent with an approach which enables the court to achieve its great object, viz. Abstaining from expressing any opinion on the merits of the case until the hearing. And in our submission, that's entirely correct, that if one did apply the test that Malone and friends are contending for, there's a real risk that the court would get into the dangerous situation of expressing opinions on the merits of the case prior to the trial, and having to make findings as to who has the better of the case. We say it's realistically impossible, or at least highly unsatisfactory, for a judge to have to make determinations on as to hotly disputed allegations. We say that if Malone and Friends' test were applied, the court on freezing injunctions would be deluged with material in an effort to persuade the court that one party or the other had the better of the argument. And we say that's a more serious consequence than in the jurisdiction context, because the issue to which good arguable case relates in a freezing order context is the merits of the entire case. All causes of action, all defences, foreign law, and so on. Whereas in the jurisdiction context, it is not always, but quite often, a fairly discrete issue. This places increased strain on the court's resources. It would turn freezing order hearings into mini trials. It will also make it harder to obtain freezing injunctions. It's particularly hard for applicants to satisfy a merits test in the freezing injunction context, where the claim is usually one of fraud, which means that quite often the claimant does not have all the material they need to prove their case, because fraud is usually covert. Injunctions are usually obtained at a very early stage, quite often with a great deal of urgency, and where it's difficult to put together the strongest case possible on the merits. And there's not necessarily such a degree of urgency or such an imbalance of knowledge in a jurisdiction case, where the issue is the question of whether the jurisdictional gateway is or is not met. So we say that the need accession test is not just right as a matter of authority, but it is preferable as a matter of application as well. My Lord, there's still time. Those were my submissions on that issue. Can I turn? The next issue is whether or not there is a good arguable case here, which itself I had was going to analyse in 2 steps. And maybe the sensible thing is for me to do 1 step, but not the other in the time available. The 2 steps were one is the question of English law, is to what extent should this court interfere with the assessment of the first instance judge on this question. And the second question is predominantly a question of Angolan law, as to whether we do or do not have a good arguable case. So is it convenient for me to address your lordship and your lady on one of those? Yes. So the first sub-issue is we say it's clear as a matter of authority and as a matter of principle that this court should respect the instincts of the first instance judge on the question of good arguable case. And this has been repeatedly stated in the case law, as I would like to show your lordship and your ladyship now, please. So if we please could go back to the authorities bundle at tab 20. Which is back into the Lacatamia and Sue case, tab 20. If we can pick that up, please, at page 331. So it's tab 20, page 331, and it's paragraphs 26 and 27, where the judge said that despite counsel's able advocacy, he couldn't bring himself to conclude that Mr. Justice Beatson was wrong to say that the case was more than barely capable of serious argument. He says this is not a matter of deferring to the commercial judge, but it must be remembered that applications for freezing injunctions made on the basis of a good arguable case come before the commercial judges all the time. Derived from their time in practice, they've developed what's perhaps best described as an instinct as to what's well arguable and what's not. That instinct should be respected by those in this court without the everyday experience of granting and refusing freezing injunctions. Although your lordship and your ladyship may have had that experience in the past, but I think the point is that this court should respect the well-developed instincts of commercial judges making that sort of decision.
Slightly surprising comment, given the relative experience and expertise of Lord Justice Longmore on the one hand, and Mr. Justice Beatson on the other.
But it's a well repeated comment, my lord, and we see it again.
It's a self-denying audience.
In if we can please go forwards to tab 22, Lord Justice Longmore again in Kazakhstan case at paragraph 16, which is at page 426.
Hang on.
Sorry, yeah, so it's tab 22, page 426, Lord Justice Longmore, paragraph 16, please, says it's common ground, must show a good arguable case. Normally, if a judge of the commercial court decides that a claimant has a good arguable case, this court would not interfere with that conclusion unless, which is unlikely, he makes an error of law in coming to that conclusion. That is a point that is then developed at paragraph 22 of the same judgment at page 428. The judge, where Lord Justice Longmore says, the judge has here made an evaluation of a mass of material. This court should not interfere with that evaluation unless it's obviously wrong or the judge has misdirected himself, and then he makes the same point about commercial judges having a lot of experience. And then on paragraph 23, he identifies some arguments that Mr. Howard had made, and then under the fifth one, in the middle of the page, he says this is no more than a rerun of the arguments submitted to the judge. He says it's very important that applications to discharge freezing applications do not turn into mini trials, and that should be resisted. Can I invite your lordship and your ladyship also to look at what Mr. Justice Elias, Lord Justice Elias said on this at paragraph 62 in the same judgment at page 438, said the Court of Appeal ought to respect the instincts of experienced commercial judges. And those are points are repeated. I won't take your lordship to every one of them, but also in Morimoto, Lord Justice Haddon Cave repeats that analysis at paragraph 78, which is in the authorities bundle behind tab 30 at page 659. And we say that is the appropriate position to take as a matter of principle, because the first instance judge generally has a longer time to consider the application in its full context with fuller argument. We had 2 days before Mr. Justice Bright arguing these points, and the points that my learned friend Mr. Olive Cooper made were all ventilated. Well, they had the opportunity to ventilate as many points as they wanted in front of him about Angolan law, and there was full argument about the principles of Angolan law. And as your lordship sees from, and we ventilated our own points on Angolan law, and the judge came to his decision on that.
Well, there are questions of fact
Yes,
on which we wouldn't interfere unless we were satisfied that the judge had either failed to take into account something he should have taken into account, or taken into account something he shouldn't have taken into account.
This may just be a particular application of the principle in sprint room and other cases like that, that where there's an evaluative assessment at first instance, not a discretion properly so called, but an evaluative assessment, then this court is slow to interfere. I'm not sure that it's something which applies particularly because this is a freezing injunction context.
Yes,
It's that more
It's true of
general
any
principle.
valuation of fact, including foreign law, in one sense, a forcible foreign law.
Yes, my lord. And that's what. And otherwise, firstly, well, it's a self-denying ordinance, as I think my lordship said, because otherwise, unsuccessful litigants will seek to appeal cases and re-argue exactly what they argued first time round and lost. That's not the function of this court. So, my lord and lady, I'm sorry. Time does not permit me to argue the points on Angolan law, but perhaps we can come to that next time.
Well, realistically, if we were to stop now, we've had quite a long day.
Yes.
How much longer do you need to deal with the further issue of Angolan law, which Mr. Cooper, and the limitation relation back point?
Not terribly long, but I would say 45 minutes to an hour. But
and then there's the costs.
there's the cost issue. So I would have thought my own friends were spending a
You may
day.
have some further thoughts or unearth some further material.
And maybe some Commonwealth authorities. I guess half a day would be pushing it, so a day would be more sensible.
Well, that's why I'm answering the question. Exactly why I'm
Yes.
answering the question. I think we've got to find another day. Quite when that will be is maybe problematic, I'm afraid. Getting the same constitution together. And we can certainly try and do it before the end of July, certainly. But I know from my own diary that I've got a lot of quite heavy appeals coming up. Some of which are being sort of crammed into spaces.
The other alternative, my lord, is that we could do in half a day. We could do everything, not including the costs, if that makes life easier. And then, so your lordship and your ladyship could have heard all the issues on good arguable case at least.
Well, that's a possibility. Perhaps not all that satisfactory. What I think we should do is that you should let Court of Appeal listing have your respective availability between now and the end of term. We will see if we can fit something in.
Yes. Thank you.
Okay?
Very great.
Well, we'll adjourn for now with a view to reconvening, as I say, if possible, before the end of term. Thank you all very much.
What race people?